You're reviewing an applicant's credit report and you see on there that there's a bankruptcy from 2 years ago and it says dismissed. Maybe there's even multiple bankruptcies and it says dismissed. Is this a good thing or a bad thing? My name is Harry Heist and I'm the founding partner of Heist, Weiss & Wolk, the property manager's partner. The property manager needs to understand what bankruptcy means and what it means to be dismissed or discharged. An applicant may come to you, and when running the application, you will see that there is a dismissed bankruptcy. Now, what does this mean? Dismissed. Is that a good thing? Possibly not. A dismissed bankruptcy is where someone filed a bankruptcy with the bankruptcy court for whatever reason, and then did not follow through with the bankruptcy. Or possibly they filed the bankruptcy and the bankruptcy judge felt that the bankruptcy was not proper. Therefore, the bankruptcy was dismissed. Dismissed sounds kind of good. Dismissed means they never really filed bankruptcy, but they did file bankruptcy. They filed bankruptcy and simply did not follow through with the bankruptcy. What does this mean? Why did they file bankruptcy? Sometimes people file bankruptcy to stop certain litigation. For instance, if you're under eviction, you could file a bankruptcy and you'll stop that eviction dead in its tracks and buy yourself some more time. If you're being foreclosed on and you're just about ready to be removed from your house, you can file a bankruptcy and stop the foreclosure action. So you see, bankruptcy is sometimes used as a tool by people to stop litigation. And it does. Bankruptcies stop. They suspend litigation, forcing the other party to go into court and to have a stay of bankruptcy lifted. So when you see a dismissed bankruptcy, it could mean that the tenant used bankruptcy as a weapon. They used it as a tool to potentially stop an eviction or foreclosure, something before. The problem with a dismissed bankruptcy is that it can be filed again. You could file a bankruptcy, you could dismiss it on your own, or the court could dismiss it because of failure to move forward on the bankruptcy, and you could file a bankruptcy again. So when you see dismissed bankruptcy, you should think that this person could be dangerous because they could file the bankruptcy again. They may, we're not sure, but they may be using bankruptcy as a tool to stop litigation or to try to get some kind of edge in court. So dismissed bankruptcy is actually quite dangerous. Now, discharged bankruptcy is different. If you see that someone filed a Chapter 7 bankruptcy and it was discharged last year, that's actually good because that means that the tenant filed bankruptcy and their debts were either completely discharged in bankruptcy and they don't owe anything to anybody, or maybe they're on some kind of a court-approved payment plan through the bankruptcy court. So discharged actually is good because most likely your tenant's in a fairly good financial condition right now. Sure, they can't get credit. We know that because they have this bankruptcy on their record, but they also may not have any debts. So possibly that would be someone good to rent to. Now, if they're in an open bankruptcy when they apply, this could be problematic. When someone's in a bankruptcy, they're in an open bankruptcy, they're subject to the jurisdiction of the bankruptcy court. You see, the bankruptcy court does not want someone who files bankruptcy to pay this person and not pay this person, to pay a friend of theirs and not pay a hospital bill. The bankruptcy court determines what needs to be paid and who is going to be paid, the priority of who's going to be paid, if anything. So it's dangerous to rent to somebody in an open bankruptcy because they might be in violation of the bankruptcy court. You might have someone who's in an open bankruptcy and wants to rent a $3,000 house from you. But the bankruptcy court hasn't given them permission to do that. So now they're paying you $3,000 each month. The bankruptcy court gets wind of it, and now the bankruptcy court wants their money back. Can it happen? You bet it can. We've had it happen to clients before. If someone's in an open bankruptcy, that's dangerous. So what do? If you have an applicant come to you and they're in bankruptcy, or they have a dismissed bankruptcy, or they have a discharged bankruptcy, and they don't meet your resident selection criteria, then what you can do is have the owner of the property override what normally would be your decision. If your decision would be to deny the applicant, and you feel like this applicant maybe still is worthy of renting, and maybe they have a good job right now and you feel comfortable with them, have the owner make the decision. We have a form called the Owner Authorization to Rent. This is the form that's used in a situation where, for instance, there's a bankruptcy and you would not normally approve the application, but you're giving the owner the opportunity to make that decision. You don't want an owner coming back after you 3 months after you've put a tenant in there that's in an open bankruptcy or had filed a bankruptcy, had a dismissed or discharged bankruptcy. You don't want that owner coming back after you trying to blame you because their tenant's not paying the rent. If someone is not approved according to your resident selection criteria, let the owner make that decision so it's not on you. Protect yourself, be safe. If in question, have the owner make that decision. If you have any questions regarding this, if you would like to have a copy of the Owner Authorization to Rent letter, feel free to email us at info@evict.com.